Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic, when will it be the end of global anti-suit injunction wars? Present and prospective FRAND litigation and arbitration in China. In recent episodes, we've taken a closer look at FRAND in the United States and abroad. In this episode of Our Curious Amalgam, and our final in this FRAND series, we set our eyes on China to better understand the ongoing debates and developments in FRAND litigation and arbitration there. Joining me today is my co-host, Anora Wang. Hey, Anora.
Hi, Christina.
Welcome back. So what are we talking about today?
We're talking about FRAND litigation and arbitration in China.
And who's our guest today?
Well, our guest, Jing He, has more than 20 years of experience in intellectual property, antitrust, and complex litigation in China. I want to add that it's important that we have Jing to talk about this topic, is that he is a leading practitioner and a recognized expert in China and abroad. He is also an entrepreneur with successes, including founding his own law firm, GenLaw, a fast-growing law firm in Beijing. Jing has led or handled many cases that were selected for publication as top IP cases by Chinese judiciary authorities. Jing is also a recognized thought leader and policy advisor, having been relied on as an expert consultant in various policy programs, including a key U.S.-China IP dialogue. Jing started his legal career here, actually, in the U.S., having obtained a JD from Notre Dame and about a decade of experience as a patent attorney with a major law firm here in the U.S. before he moved back to China to start his private practice there. He also holds a LLB and BLC from Peking University, so we're very lucky to have him.
Very lucky indeed. Well, without further ado, welcome to the program.
Thank you, Christina. Thank you, Anora. It's really great to be here.
It's our pleasure. And as Christina already briefed, we in our Curious Amalgam program try to bring our audience up to speed about FRAND issues here in the U.S. And elsewhere, including in EU. And China is obviously a major jurisdiction now. So start off, how can an audience who has like no experience or very little experience with litigation and IP would know what it's like to actually litigate FRAND issues on a global scale?
Well, in China, the FRAND matters actually started more than 15 years ago. And at the very beginning, it's really starting off by it's actually starting from the DVD era. That's the time that some of the DVD licensors, went to China and then collecting the fees. From that moment, the Chinese companies and the public, the governments starting to know that, wow, IP is not just all for pro-innovation. It's some kind of a pain, which means that, China got to pay the patent royalties. Sometimes our country make this a little bit personal. Keep that in mind. Actually, that's very important. Now, coming to right now, and the biggest thing in the FRAND licensing is really relates to all this wireless communication standards, 3G, 4G, and now the 5G. And what's been interesting is that the Western patent owners are negotiating for years with the implementers around the world, including the one from China. But it looks like the negotiation with Chinese implementers probably take longer than what people were expecting. So the patent owners are initiating the enforcement actions around the world. But mostly all this litigation happened outside China. The one of the famous one it was in the UK, the Anora Planet, as I think our audience have heard about. Now, what the implementer got to do is that they're trying to find a way to protect themselves. What they end up doing is that they actually file the anti-suit injunctions in Chinese court, asked the Chinese court to grant the injunction, the anti-lawsuit injunction, against the patent owners, prohibiting the patent owner from filing the patent litigations or seeking injunctions outside China. This is what we call anti-suit injunction. This is not really invention of a Chinese court, just so everybody knows, right? And the ones I actually first run into was the one done a couple of years ago when Huawei and Samsung were litigating in China on their FRAND case. Samsung actually somehow successfully managed to get anti-suit injunction against Huawei in the US, which I think lots of people believed somehow really important eventually to cause a settlement between both companies. So what's really happening in China right now is that we at least have 3 anti-suit injunctions that we heard that are granted by the Chinese court against the companies, including like InterDigital, against the Ericsson, and against Sharp.
Mm-hmm. I think you mentioned several things that's important and probably worth breaking up and highlighting. For one, anti-suit injunction. So for people who don't know, this is essentially someone who go into the court asking the court to forbid the other party who is in the litigation to prevent them from bringing a suit elsewhere, essentially. So, and I think you mentioned the anti-suit injunction as well. That's essentially going to another court, asking that court to say, no, the first court, you cannot issue that first anti-suit injunction, right? It's kind of childish movement, like calling essentially, no, I stop you from making the next move, and then you go to the other rule and say, no, the first ruling is not effective. Isn't that essentially what it is?
Oh yes, that's really the battles between the courts. Actually, a couple of years ago, I was predicting there could be a quote unquote the world war of courts when it comes to the standard essential patents. And unfortunately, that's really happening. Courts, the judge is supposed to be the wisest person, right, in every society. But right now they are using this anti-suit injunction or anti-suit injunction. There are even the AAASIs, anti-suit injunctions. Now, the recent case, what we heard in China, what happened in the case between Oppo and the Sharp in the Shenzhen court. The Shenzhen court basically issued even anti-suit injunction from the very beginning, prohibiting Sharp from getting an anti-suit injunction outside China. That's already preventive.
So you're calling dips essentially on what other people can do.
Yeah, and some kind of mathematics, right? We all learned before.
Right. So the anti-suit injunction and ASI and AASI. So that's obviously not a healthy dynamic that we're looking at, but there are reasons why they exist. But that's essentially that's the current situation that we're in globally. That's not just in China. Is that right? And China just happens to be a key player in this ASI and AASI dance. Is that right?
That's right. I mean, one of the most important reasons is that the Chinese company, the implementers, went to the Chinese court under this, the contract disputes as a cause of action, asking Chinese court to issue the ruling on the FRAND rate, basically saying, hey, please, judges in China, please determine the FRAND rate for me.
Yep. So this is a good point to connect to some of the past episodes. We explained what FRAND is. It's essentially a commitment that a patent holder is making to either a standard development organization or standard setting organization, saying that they're going to license their patents under a fair, non-discriminatory manner. And then the rates essentially is not determined, right? FRAND is essentially some good principles guiding the negotiations, but the rates are not ultimately determined. And courts are doing that in China and elsewhere?
Yes, it's quite interesting. I mentioned this Our Planet case. That's actually probably the most famous case in this area. And Judge Burrs in the United Kingdom issued the ruling on the global FRAND rate in a patent infringement case. He basically was telling the Huawei, the Chinese company, to say, hey, I'm going to issue the injunction, but at the same time, I'm also determining the rate. If you pay the rates, you're not going to subject to the injunction. So that's how it happens. But in China, we twist it. What happened is not the patent owners go to the court, right? Normally, you got to be patent owners filing the infringement lawsuit. Ask the court have a chance to determine the damages and then the relevant to the rate. Now, in China, our companies go to court to say, hey, because the patent owner has a FRAND obligation, it's more like a contractual obligation. So I'm asking the court to determine a rate for us. Obviously, people worry that, hey, Chinese court have this, Chinese implementer have this home court advantage. That's what's all this about.
I think that makes great sense. Essentially, we're talking about innovators and implementers. They're trying to have rates determined, and some think their home courts would be more advantageous or more friendly to determine rates that's more favorable for them. And China becomes an important battleground because there are, well, at least up to this point, more implementers than innovators in some of the FRAND dynamics. Is that right?
Right. And the Chinese mobile phone companies are becoming so successful. Obviously, Apple still get all this biggest profits, right? Biggest name. But now if you're looking at the Xiaomi, Oppo, you probably heard about the Vivo or OnePlus. Most of this are coming from China, and all these implementers are getting very successful globally.
I think that's a fair point. But soon people are going to worry. So either it's more innovator or implementer friendly. Should any jurisdiction, including China, welcome this power, I guess, that's coming to its arms when people are coming to your doors asking you to determine rates, sometimes globally, right? So there are some jurisdictional concerns. What is the current thinking in China? Like, what do you have observed? What are the judges thinking? I'm asking you too much to speculate here, but what have you observed? Is it more welcoming the authority, trying to explore what can happen, or more of like, let's be more conservative. Let's see what we should not do?
Well, Chinese judges are very aggressive on this. And we're not just speculating. There are some public research reports or articles written by the Chinese judges. They're actually clearly pointing to the fact that UK judges were awarding the global rate. The judges were asking, how come or why we cannot issue the ruling on the global FRAND rates? They're starting from a Chinese local, the China patent rates, royalty rate for Chinese patent portfolio. Then they move on to say, we think we can do that as well. If you're looking at some of the cases, like the recent case between the ZTE versus the Conversant, Conversant is a Western patent owner. The judge pretty much upheld the jurisdiction for the Chinese judge, Chinese court, to rule on the China rate. The reason pretty simple. They're saying that we're talking about the Chinese patents here, and the Chinese implementer implements these patents really in China, right? And lots of manufacturing are done in China. So far, we have not seen a appellate court ruling on the global FRAND rate, but there are some district courts already issued a ruling clearly stating that they have the jurisdiction over the global rate.
I'm glad you brought up. Go
Sorry,
ahead.
just to step back. You mentioned the UK courts. I'd be interested in hearing if there are other sort of jurisdictions that are exerting some power in this space. And then when we talk about jurisdiction, I had always thought, there's a Chinese patent. They're going to talk about the rate for the Chinese patent. There aren't, at least maybe you can correct me. I didn't think that there was a global patent. So when you have a patent, you have to apply in each jurisdiction to get protection in the UK and the US and in the various jurisdictions. So how can there be a quote unquote global rate for a patent.
Yeah. Well, this is a patent licensing business. If you're looking at actually the best quote or best the famous statement about this from the Judge Burrs in the UK, he basically said that I got to really work on the global rate. Otherwise, it makes no sense because everybody make the offering as a global rate. Nobody really licensing on country by country basis. So commercially, it's true. Okay, it actually makes sense. But legally, people starting to litigate on the different countries. Actually, not many countries. U.S., UK, Germany, I think Netherlands, India. This is our the popular jurisdiction at this moment in China. But China is a little bit different. China is probably the only one that implementer initiate this contractual dispute, asking the court to determine the rate. For most of the other countries, it's a patent owner initiating the enforcement action.
Yeah, I want to connect to one point that you said before. You brought up the Conversant case, which I think, correct me if I'm wrong, I think that was decided by an IP court in Nanjing, right? So
Yes.
IP court is very much a feature of Chinese judicial system. It does not exist here. Well, we have the federal circuit here in the United States, but it's different. Could you tell us a little bit more about the features of Chinese judicial system and how is that ready or not ready, in your opinion, for setting global rates or settling these global disputes?
Right. Well, I think very briefly speaking, China, the court system is not a federal system. Okay, to give you a background of our American audience, it's more like a one state court. Okay, it's like a big one state, right? That we have the many courts that any local court ruling has a national binding effect. And we have this specialized IP court, which was somehow actually modeled on the CFC, the specialized courts in the US. Of course, initially, right, CFC is not designed for patent cases. Now, 70, 80% cases are patent cases. So we have the specialized IP court at the court of first instance levels. And now we also have a Supreme Court IP court, which is more like a appellate level. And our court proceeding is very similar to probably German proceeding in a way, because our patent law is a more German model. But in all the recent years, we've been introducing lots of American elements. It's more like a German model with a lot of American elements.
So one of the American elements I imagine would be about discovery, right? How broad it can be and how people can engage, how parties can bring expert witness. So I know you have two great articles, which we're going to put links on our website so that people can read more about it. But can you elaborate a little more some of the procedure aspects or concerns that people might have? Including how expert witnesses or due process are played out in this process.
We discovery is the American element we do not have so far, okay? Because we do not have this kind of American Bar Association. Our Bar Association is not that powerful, strong, and it's more like a European or continental system. I mean, judges are taking a much more active or inquisitorial role, right? They are more proactive. And actually, in one of our recent cases related to FRAND obligations, the judge actually really pushing both sides around, asking the both sides to present evidence, and also allow both sides to issue a list of documents or evidence for the other side to produce. So we are trying a little bit of that, but it's really up to the judge to handle. Now, another big thing is whenever it comes to patent cases or FRAND or antitrust case, how experts are allowed in China is a big thing. The good news is that we are actually using more and more expert witness. In fact, some of the American educated or with American professional experience economists are actually getting very active in Chinese court. Believe it or not, they've been testifying more and more FRAND cases and antitrust cases.
So that's good. So I guess with the combination, obviously we're oversimplifying things here. With the combination of not so broad discovery, which is costly here in the US. And then you have the specialized courts like the IP courts in China. And then comes with the specialized court, you have the more specialized judges. And then you also have the inquisitor, the features that's more efficient in China. Would this make FRAND litigation in China generally a better among the alternatives? Would it be more cost saving or more efficient in deciding FRAND rates?
Well, it might be more efficient, but right, efficiency is only part of the policy goal of the court system. I think the biggest challenge right now is that how can our system be trusted by, let's say, the Western patent owners? Many people actually have the concern that how could we allow the implementers to file such a contractual dispute to get FRAND rate determination done in China. There are still lots of controversy in this part, even though the Chinese judges think they're fully convinced that they have the right to do so. But it's a little bit, it's still somewhat controversial.
Mm-hmm. I agree. And I'm glad that you brought that up. Obviously, there are reasons that people think certain system might be biased in certain ways. This might be a good point to shift gears a little bit because we have litigation and arbitration both in the title. So let's do the part about arbitration. So do you think the arbitration system in China is growing and cultivating, I guess, certain aspects that make it a better possibility to decide the global FRAND issues in China?
Supposedly, okay. I think arbitration supposedly should be a better choice because if you're looking at all the FRAND disputes, it's really a commercial in its nature, very, very commercial. Like you said, the FRAND is a very big principle, which is very smart, right? Allowing the standard to be implemented at the early stage without too much concern over the patents, the powers. So it's really up to both sides to come up some decent commercial terms. Now, if that cannot be done, it's actually better to go to the arbitration rather than using up so much court resources. It's very exhaustive, actually very much exhaustive. I had this call, I recently had the honor to talk with this famous UK judge, Robin Jacob. He's fully believed that all these cases should go to arbitration instead of going to the court. You're supposed to go through lots of we call FRAND trial, whether this particular patent is a standard essential or not. So lots of technical analysis if we want to be right in a procedure. Right now, judges are cutting corners. That's not the right way to do it. So it's better let the expert deal with this in arbitration proceeding.
Mm-hmm. And is there a challenge to the fact that arbitration tends to be, a private proceeding between two parties in terms of it being fair and non-discriminatory and reasonable and all those things that we want to apply to, across the board? Or is there a way to sort of use arbitration and still allow it to be sort of open and accessible to others in the marketplace?
Right. There are some critics that exactly go to that way, right? Sort of a little bit secretive. But I think the bigger point, the bigger challenge is that where we can find this kind of arbitration space, arbitration centers, arbitration platform where they can get trusted by both the Western patent owner, Western parties, and Chinese parties. Chinese parties, for all these years, we observed that they have the resistance to be arbitrated even outside China. This is not just China. IP cases, we see this very clearly, even for those commercial arbitration cases. Chinese parties hate to be brought into London or Zurich for all this ICC, or brought to the US or even Singapore probably for arbitration because they're not really comfortable. So for those FRAND cases, there's the same barriers. People are. The Chinese companies are concerned, hey, if I brought into like ICC arbitration, hey, I don't even see a Chinese face. Am I gonna really get a fair treatment? And plus, there's even no appeal, right? Like Christina said, that's the trouble here. That's why in my article I had this sort of bold, maybe even fantasy proposal: can a China-based arbitration be maybe the solution? I mean, when I say China-based, it does not mean it's just all Chinese-based arbitrating. Right. I'm pretty sure that's gonna scare the Western parties as well. Sorry, it's really human, right?
The jury like of your peers, right? Who's your peer?
Yes, absolutely. We're hoping that maybe our new arbitration center can be built in a way that's gonna be more open, gonna be really taking up all these greater features of the other international arbitration centers. Right now, there were some active talks about setting up a China-based international arbitration center. We don't know the exact status right now, but we know there were some very active talks.
I want to connect our talk about arbitration on 2 points to what we just discussed. One is that, so do you think with arbitration we can just cut off all the anti-suit injunction and anti-suit injunction dances? And two, just not just parties who are concerned in arbitration, but also people who want to have precedents set through previous litigations. Would that actually be a drawback, that when you have more things being arbitrated, then you don't have these cases that you can rely on in later resolutions in trying to decide, disputes between parties?
Those are really great questions. The first one, I think if we can find this great arbitration place, whether China-based or Japan-based or based on multiple just locations, somehow we can find a way to build something like Western parties and Chinese parties that feel comfortable to arbitrate. I think that will definitely save all the trouble from the court. I really believed that the judges are competent, but they're supposed to spend their resources on something else rather than this pure commercial, dispute on the rates. The second one, all this the publicity feature or transparency feature. My personal opinion is that the people who are involved in all this licensing world, the FRAND licensing, are a group of highly professional, highly experienced professionals in a very sort of a focused, condensed industry. I mean, they know what should be the reasonable rate, to be honest. I do think people knows that. They're not too much a secret here. Yeah. You don't really need a precedent, especially for now, okay? Maybe 10 years earlier, when the whole thing started, when 3G licensing started, maybe you will say, I would be compassionate with people in my country, right? Some of the Chinese companies, when they were very at the very early stage, they lack experience, they don't know that much. Maybe they're, the kind of concern you have are pretty valid. But now, Chinese companies are among the biggest patent owners these days. They are doing a lot of licensing work, and they're very, very active. I'm just talking about the Chinese companies. I'm not talking about next generation. Plus, Chinese licensors like Huawei are doing more of a licensing work themselves. So the lack of transparency may not be that a huge concern.
So I have just one final substantive question, which is to ask you to read the tea leaves. What have you observed? What do you think is going to happen in the IP antitrust world generally, and in relation to FRAND specifically?
There are probably still some brave parties are still gonna rely on the court litigations. But I'm predicting that people probably gonna really get more mature in a way that all the frustration out of the ASIs will probably have people make some more of a bold judgment. They're probably going to look in some more alternative way to resolve the disputes.
Great. Well, Jing, this has been fascinating, and I think a wonderful way to sort of close out our series in a very complex, real life examples of how FRAND can play out in China and globally. But before we let you go, we do like to ask all of our guests a few questions so we can get to know you a little bit more on a personal level. And one question we asked all of our guests is to tell us something about yourself that we wouldn't know if we only knew you professionally.
Sometimes I was on the Chinese TV, the English channel, talking about current affairs, talking about what's going on politically or economic trends. It's fun to do that. I actually even started a podcast out of inspiration of the ABA Antitrust, but I gave it up after 6 episodes when I realized, well, not that many people were listening. I guess people stopped commuting, right, during the pandemic. So This is probably not the right time for the podcast. We're talking about the 2021, right?
This will be the revival of your podcast, right here.
All right.
And do you have any advice for young professionals or students who are interested in doing what you do? You kind of almost went, a lot of folks are practicing abroad and come to the United States to get an LLM. You almost did the opposite. And you've had an interesting professional trajectory. So, any life lessons that you'd want to impart to our listenership?
I think when we speak into especially our American law students, I really, really highly encourage, people find some opportunity to come to China, get some professional exposure. One of the things I truly, truly enjoy in the last 5-6 years is that we were able to invite some of those American law students, like from Notre Dame, right? So where I came from, to spend a few weeks with us, doing some research and just getting around in our system. I think that's should be really, really beneficial. Like I benefited tremendously from my American education, my work experience in U.S. law firms. I think the same thing gonna apply to our American law students, our American lawyers.
Great. And now we're going to turn to our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
Nothing like a way to end an episode with some hokey music. So, Jing, if you can pick a number 1 through 25.
17.
17. What was your favorite course in either college or law school?
Trial advocacy.
Okay, well, you're in the right business. And is there a course, you didn't even hesitate to answer that. Is there a course you wish you had taken in law school that you didn't?
It's very funny. I'm a nerd. I'm a deposition.
We should change that question. If you're not a lawyer, what would you be?
What would you do
as a profession?
I know. It will be the educator, personal development educator, coach.
Great. Well, Jing, thank you again for your time today. And to our listenership, thanks for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.